Welcome everyone, and thank you for joining us today on Level Up Law. We're here at South Carolina Legal Services. We are leveling up your legal knowledge on the different areas of law that we practice in. Hello, I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I will be the moderator of the webinar today. We are joined by South Carolina Legal Services Family Law Unit Head, Melinda Taylor. Melinda will be reviewing for you the basics of child custody laws in South Carolina. Now, please keep in mind that this is just general information for the public and not legal advice. You should always consult with an attorney for any specific legal issues that you have. You can put any questions you have today in the question box, and we will try to answer those in the time that we have available. Also, please note that the webinar is being recorded, and the recording and the slides will be posted on our YouTube channel for South Carolina Legal Services later this week. Information about how to apply for free legal assistance at South Carolina Legal Services will be provided at the end of Melinda's presentation. Today, during the webcast, all attendees will be in the listen-only mode. Again, thanks so much for joining us, everyone. And now I will turn it over to Family Law Unit Head, Melinda Taylor.
Thank you, Susie. It's good to be here, and thank you for inviting me to speak today. So today we're going to talk about custody cases in South Carolina. The family court is the court that has jurisdiction to hear custody cases in South Carolina. And the family court can also decide other things like visitation, divorce, child support, and a whole lot of other things that has to do with families that are either separating or there's custody issues. So in order to file a case, and I've got to, I'm sorry. I've got to figure out how to move my slides, and I apologize. There we go. Sorry about that. All right, so in order to file a custody case in South Carolina, you've got to, there are some residency requirements. First of all, if both parties or all the parties live in South Carolina, then you certainly could file in South Carolina. However, if you've just moved to South Carolina from a different state, the child should have lived here at least 6 months. Now, there are exceptions to that. Like if the child's in danger or maybe he's been abandoned in the state and things like that. Custody cases are usually filed in what we call the child's home state, which is defined as the state that the child last lived in for the last 6 months. Just to start with, if you have unwed parents, so a mother and a father that have a child together and they haven't been married to each other, then in South Carolina, the mother is actually going to have legal custody of the child. And that is until until one of the parties goes to court to change that. So certainly a father could petition the court for legal custody or visitation of the child. But until that happens, then the mother would have legal custody and the right to allow or deny visitation with the father if they're unwed, if they've never been married. The father can either acknowledge paternity. A lot of times that's done at the birth of the child, where he is put on the birth certificate. Sometimes it's done in court where he and the mother acknowledge that he's the father, but it can also be done through DNA testing. So just so that we make sure we're using the right terms, there's all sorts of terms that are used with custody. There's legal custody versus physical custody. We're also going to talk about sole custody versus joint custody, shared custody versus split custody. There's all sorts of different terms. So let's go ahead and define the terms. So legal custody basically just determines which parent has the right to make decisions for the child. And then physical custody is where the child is physically placed or the amount of time he spends with the parent. So you could have a mother and a father that have a child outside of wedlock, and the child lives with the father. So the father would have physical custody of the child. But technically the mother would still have legal custody until the father goes to court. You could also have situations where the mother or the father have physical and legal custody. And that's probably a little more common. So the terms sole custody and joint custody. Sole custody is when only one of the parents or one person has the right to make decisions for the child. And usually there's 4 categories that the court looks at that the person would be making decisions for, and that would be education, medical, extracurricular, and religious training. There's also what we call joint custody, or sometimes people refer to it as joint legal custody. And this is when 2 or more people have the right to make decisions concerning the child. So a lot of times when people are getting divorced, they will end up getting joint legal custody of their children. And then one person will be designated with final decision-making authority. So, for example, the mother and the father get divorced, the mother and the father have joint legal custody, but the mother, we'll just say the mother in this case, has final decision-making authority. And what that means is that if the mother and the father consult about something and they don't agree on it, then the mother would basically be the one to make that final decision. But the mother would always have to consult with the father prior to making decisions for the child. So we also have the terms primary custody and secondary custody. And a lot of times you'll see this when you do have the joint legal custody as opposed to sole custody. The primary is usually the person that's going to have that decision-making authority. And then the secondary custodian would not have that decision-making authority. And then less popular terms, I guess, or less used in the family courts is going to be split custody and shared custody. So split custody is when one parent has custody of one child and the other parent has custody of another child. And now we don't see this a whole lot, but let's say mom maybe has custody of Sally and dad has custody of John. So that would be split custody. And the courts are reluctant to order such type of arrangement. However, sometimes parents think it's in their child's best interest. They come to an agreement, and then that is what they do. Shared custody is whenever the parents have equal or close to equal time with the children. A lot of times you'll see this on a week-to-week basis. There's other scenarios like maybe they're on a 2-2-5-5 schedule to where both parents are almost on an equal playing field. And a lot of times with those type of agreements, you'll see that they make decisions for the child during their week. So, and that's again a rare or not as common type of custody arrangement. So no matter what type of custody arrangement you have, parents are always going to have the right to access information about education, medical records, and then also have the right to appear at or participate in school activities that are in a public place. And that's a right that parents have no matter what the custody arrangement is, unless there's a court order prohibiting it. So when you bring a custody action, the court's going to look at factors to decide who is the best person or persons to have custody of the children or the child. And there's 17 factors that the court looks at to determine this. And sometimes one factor may weigh heavier than another, and it depends on the cases. So it's really hard to determine who may be the custodial parent at the end of a custody case. And sometimes, you know, the factors just really could be equal between the parents. So a lot of times it's very hard for judges to make decisions. But these are the factors, and I'll just briefly go through them, that the court is going to look at to make a determination on who's going to get custody of a child in a custody litigation case. So the first is the temperament and developmental needs of the child, the capacity and disposition of the parents to understand and meet the needs of the child, the preference of each child. Now, with that, everybody always asks, well, how old does my child have to be? You know, when they turn 12, do they get to decide? And the answer to that is there's not really a magic age. However, when the child does get to be about 12, 13 years of age, if they are making a preference towards living with one parent over the other, the court will certainly take that into consideration. But it doesn't mean that that's the only factor that's going to weigh into that decision, because a lot of times teenagers may want to choose the parent that maybe has less rules or is more lenient and things like that. So that is one factor, but it's definitely not, it doesn't decide the case by any means. So younger children, obviously, the court's not going to give a whole lot of weight to their opinion on where they want to live or who they want to live with. Number 4, the wishes of the parents as to custody. And then number 5, the relationship between the child and each parent, his siblings, and any other person that may affect the child's best interest. Number 6, the actions of each parent to encourage the continuing of the parent-child relationship. So if you have parents that are disparaging the other parent or fighting, you know, or if you have one parent that never does that and the other one always is putting the other parent down in front of the child, that's a factor the court can look at to decide who the children should live with. So as well as number 7, the manipulation by or coercive behavior of the parents in an effort to involve the children in the parents' disputes. It's probably always best to try to keep the children out of the adult disputes or adult conversations. So the court will look at that, like, has this person trying to pull the children into these arguments and persuade the children that, you know, mom is a bad person or dad is, you know, a drunk or whatever. Number 8, an effort by one parent to disparage the other parent in front of the child, courts frown on that. So if you're in a custody case, or you think you're going to be in a custody case, you don't need to talk bad about the other parent in front of the child. And sometimes, even though people may not say something, their body language, like rolling eyes when dad calls, or things like that, can really affect the child as well. So the child doesn't need to know that you don't like dad or mom. Number 9, the ability of each parent to be actively involved in the child's life. So this could come down to if one parent is let's say a truck driver, and they drive 7-8 days straight, and they're only home for one night. So in a 2-week or a 1-week period. So, but the other parent lives right there and can pick the child up from school and go to the soccer game and things like that. So that's going to be one factor as well. And then the child's adjustment to his or her home, school, and community. That's another factor. Number 11, the stability of the child existing in proposed residences. So the court's always going to look at which parent offers stability, and which parent is least likely to maybe lose their housing or change the child's schools and things like that. Those are all factors that are going to come into play. Number 12, the mental and physical health of the individuals involved. Now, disabled parents can get custody of their children, and a lot of times they're very good parents. So that's not something that would disqualify somebody from being a custodial parent by any means. But certainly if their health was to the point where they couldn't care for the child, and maybe the roles are reversed, now the child's caring for the parent, that could be a factor. And then of course, mental health is always at issue in cases like this. Court will also look at number 13, the child's cultural and spiritual background. 14, whether the child or a sibling has been abused or neglected. So with abuse or neglect, you're looking at, has the other parent been the perpetrator, or maybe allowed a perpetrator near the child? So those are all very important factors for the court to consider in a custody case. And then number 15, whether one parent has perpetrated domestic violence or child abuse, or the effect on the child of the actions of an abuser. So domestic violence cases are sometimes, very difficult to deal with. If you have one parent that's being abused and has not left that abusive situation, or refuses to leave the abusive situation, a lot of times the state will step in, DSS may step in and place the children elsewhere. But if there's been abuse and the victim leaves the relationship, then that's certainly one factor that the court would look at, who is the violent person in the relationship. And a lot of times, just because there's been domestic violence and you've been the victim does not mean that you will automatically get custody. But that's certainly one factor. Number 16 has to do with relocation. Sometimes parents need to move for various reasons. So that's certainly a factor the court can look into. And then 17 is other factors as a court considers necessary. So that means the court can basically consider anything that they find is relevant to what is in the best interest of the child. And you're going to hear me say that term, best interest of the child, a couple times today, because that's what the standard is. When the court decides who's going to have custody of a child, they are looking at what is in the best interest of the child. It's not what's in the best interest of mom. It's not what's in best interest of dad. It's what's in the best interest of the child. And that's what the court looks at to make those determinations. A lot of people ask, do fathers have the same rights as mothers? And again, whenever I started, I talked about if the parents were unwed, legal custody is with the mother. However, in the past, there's been something called the tender years doctrine. And this is where there was a legal doctrine that presumed it was in the best interest of the child to be in the custody of the mother if the child was in those tender years, which was age 4 and under. However, South Carolina has abolished the tender years doctrine. So no longer is that a presumption that the children are best with the mother. So when you start a case, you're starting it with both fathers and mothers being on equal footing, then provided that they're both, of course, fit parents. So I think that's a good move forward. All right. So there's several different types of visitation, and we'll just throw out these terms so that you can be familiar with what they are. And I'm going to talk about standard visitation, liberal visitation, and supervised visitation. So standard visitation, different in South Carolina, different areas of the state may have what they call standard visitation. And it may vary from, in Greenville may be different than in Columbia or different than from in Charleston. But for the most part, they're very similar. And usually what that means when you hear the term standard visitation is that one parent would have custody and the other parent would have every other weekend visitation from Friday at 6 to Sunday at 6. They would see the child in the off week for a few hours, usually like Wednesday afternoon, for 2 or 3 hours. They would have about 3 or 4 weeks in the summertime, and they would also get half of the holidays, and the holidays would be rotated in a fair manner. So that's your typical standard visitation schedule. You will see that a lot when you have unwed parents and the father is trying to establish some type of visitation, or if the father has custody and the mother just wants visitation. That's a typical standard schedule. Now, liberal visitation is like standard visitation, except that it's a little bit more. So instead of having the child Friday at 6 to Sunday at 6, the visiting parent may have every other weekend from Thursday after school until Monday morning when they drop the child off at school. There's usually also the midweek visit, and about half the summer, sometimes with liberal visitation, the visiting parent may get week-to-week type schedule with the other parent during the summertime, and then half the holidays, not shared holidays, but rotate the holidays. So that's liberal visitation, just a little bit more than the standard. Supervised visits would be if the court believes that there is some type of threat of safety or health or to the well-being of the child. So some types of cases I've handled that deal with supervised visits is when maybe there's been one parent has physically abused the other parent in front of the child, or one parent has abused the child, or one parent maybe has a substance abuse problem, and has or could put the child in danger. So those are the typical situation where the court could order supervised visitation. Usually, supervised visitation will be ordered at the beginning of a case, and a lot of times the parent that gets the supervised visitation will do things to work towards having that supervised visitation removed. They may attend parenting classes or counseling or different type of anger management or drug rehab, things like that. And then throughout the case, they will try to work towards establishing an unsupervised visitation schedule. So usually supervised visits are only temporary. However, they can be long-term if the parent doesn't correct whatever the problem was that caused them to get supervised visits. So if they continue to use drugs or have really unstable housing, if they're homeless and the child doesn't really have anywhere to go to see them, things like that, that could lead to permanent supervised visitation. Now, some people don't want their child's other parent to see the child at all, so they want the visitation suspended. And this is very rarely ordered because it's presumed that it's in the best interest of the child to see both parents and have both parents involved in their life, unless this person has done something to the child. I've seen suspended visitation in cases where, maybe one party was a convicted sex offender, with the sex offense being against a child. So it's definitely has to be some type of extreme behavior. The court is really concerned that if there's contact between the parents, then it could be detrimental to the child. Now, in any custody case that is contested, a custody or visitation case that's contested, the court is going to appoint a guardian ad litem. The guardian ad litem is usually an attorney. Sometimes it's a lay person that has specialized training in this area, but the court will appoint the guardian ad litem to represent the best interests of the child. So this is a neutral person that usually does not know either parent or either side, and they're going to conduct an independent, impartial investigation and advocate for the child's best interest. And what they'll do is they'll talk to the child, they'll talk to each of the parties, they'll talk to witnesses, they might go to the child's school, they're going to pull records, they're going to attend all hearings, and then eventually they're going to issue a written report that the court will read. Now, the guardian is not going to make a recommendation to the judge on who gets custody, but the guardian is just going to basically point out certain things that has happened, and a lot of times the guardian's report can be very influential to the judge, but the judge can always disagree with the guardian's report and go in a different direction. So everybody wants to fight for custody until they figure out how much it's going to cost. So an uncontested custody case, and this would be if everybody's in agreement, or maybe one person has kind of disappeared out of the child's life, like let's say an unwed mother left the child with the father and she moved across the country and hasn't been involved. She's not real interested in parenting the child. So you may have an uncontested case like that, or the parties both agree the child's going to live with dad and have visitation with mom, or the child's going to live with mom and have visitation with dad. So that would be an uncontested case. So with that, it's fairly cheap. There's a $150 filing fee, and then there's service fees. And those fees can actually be waived if your income is so low that you can't afford the filing fee. And there's a process to go through to get that approved by the court. But those are the minimum fees you're going to have in an uncontested case. Now, if you have a contested case, this is where it gets very, very expensive. Not only do you have the filing fees, the service fees, motion fees, you're going to pay the guardian ad litem. So as you can see, typically the court will appoint the guardian ad litem at a temporary hearing and order that each party pay the guardian a retainer. And usually that retainer is somewhere around $750 to $1,000. And then the guardian will bill. So just because a party pays the guardian $750 at the beginning of the case, that's not all the money they're going to pay the guardian. They're going to have a monthly bill, and they could end up spending thousands and thousands of dollars on the guardian ad litem fees. If you have a contested case, you're going to go to mediation. Depending on where you mediate at and who your mediator is, you could spend $150 to $1,000. If you have depositions, $1,000. So that, as you can see, there's all sorts of fees that could be run up in a contested custody case, and it's not unheard of. I mean, it's almost normal to have $20,000 or $30,000 cases when people are getting divorced, if you're dealing with custody, and some of them $50,000 easily. So it's always best if you can make an agreement with the other side, because you're going to save a whole lot of money. Now I'm going to switch to talking about what we call grandparent visitation, or grandparent custody, or third-party custody. And this is because a lot of times there are situations where the mother or the father or both have abandoned the child, left the child with a third party, and that party needs custody. But let's first just talk about grandparent visitation, because a lot of times there will be situations where the parents will not allow the grandparent to have any visitation with their grandchild. So the family court can order grandparent visitation when either or both parents of the minor child are deceased, divorced, or living separate and apart. If the court finds the following: the child's parents or guardians are unreasonably depriving the grandparent of the opportunity to visit with the child, including denying visitation of the minor child to the grandparent for a period exceeding 90 days. So if the grandparent has had visitation in the last 90 days, they really don't have a case. So there has to be that period of 90 days. And the following: awarding the grandparent visitation would not interfere with the parent-child relationship, and the court finds that the child's parents or guardians are unfit, or the court finds compelling circumstances to overcome the presumption that the parental decision is in the best interest of the child. So what does that mean? We have cases where the parents are deceased, maybe, and one parent's deceased and the living parent didn't like the other grandparents. So they might say, well, you're not going to see this child. So that grandparent, I think, would have to probably establish that they had some type of meaningful relationship with the child before the other parent died. You know, they were involved, things like that. That they've been denied the visitation at least 90 days, and either that the living parent is unfit, run around using drugs, leaving the child wherever, or compelling circumstances. So the compelling circumstances is very hard to define, and our courts have had situations where maybe both parents are deceased, the grandparents may get visitation, but it's hard to define. So so grandparents can petition the court for visitation, but it's not an easy task to get it. All right, so now let's move into a situation where maybe the grandparent is the custodian, whereas in the last slide we talked about just a grandparent getting visitation with a child. Whereas now we're going to move into a third party or the grandparent or an aunt, uncle, whoever, getting custody of a child that is not their biological child over you know, over the biological parent. So South Carolina has two doctrines it recognizes that allows a third party to petition the court for custody. And that would be, well, first of all, you have the psychological parent doctrine, and then we're also going to talk about de facto custodian. So psychological parent is basically the doctrine that a person who is day-to-day fulfilling that parental role for the child and providing the emotional and financial support for the child that a parent does. So they're kind of filling in that role. And then there's a four-pronged test for that. So if you were to bring a case saying you were a psychological parent of a child, and a lot of times you see this with, like, you know, the parents have left and then now grandma's taking care of the child and has really filled that role as the parent. So the parent must have consented to and fostered the formation of the parent-child relationship between the child and this third party. They must have lived together in the same household, the child and the petitioner. And they must have assumed the obligations of parenthood, meaning like they're the ones financially supporting this child or feeding this child or putting a roof over the child's head, clothing the child. And there has to have been, they need to have been in that role for a long enough period of time to establish such a bond. And sometimes you could see this with a step parent as well, like or even a boyfriend, live-in boyfriend or girlfriend, to where that person, even though they really aren't the biological parent, they have assumed that role as dad to their girlfriend's child. So de facto custodian is is another way for a third party or grandparent to be granted custody. And usually with psychological parent, it's more about seeking visitation, whereas de facto custodian is you're actually trying to establish custody of the child, legal custody of the child. So a de facto custodian is a person who has been the primary caregiver for and the financial support of the child, who has resided with the child, and the person petitioning has resided for a period of 6 months or more if the child's under 3 years of age, or has resided with that person for 1 year if the child's older than 3. So that would be if a grandma has a child for the last year and the child's 4, then that grandma would have standing to ask for custody of the child. The court is only going to look at the period prior to filing the case. So if for some reason grandma gets custody in June, physical custody in June, and she petitions the court in July, well, really, she's not a de facto custodian. She may be able to petition the court for custody based on other reasons, like there's some type of emergency or danger to the child. But as far as de facto custodian, the court's only going to look back to the time frame prior to filing and not after the filing date. So if you're to get custody of a child or visitation of a child in a court order, court orders pertaining to custody, visitation, child support are always modifiable with a substantial and material change in circumstances. So what does that mean? If, let's say, you have a mother and a father that agree on joint legal custody, and let's just say the mother has every other weekend visitation and the father has the remainder of the time. Well, let's say at the time of the order, the mother was didn't have stable housing or employment. She wasn't financially secure. Maybe she just could not take care of the child the way she needed to, but the father was in a really good position and he could. Well, 3 years later, let's say mother has now gotten this great job. She's got great housing. She's, remarried. I don't know. But father has decided now he wants to smoke marijuana and use cocaine. That would be a substantial and material change in circumstances. Whereas before, the court had weighed this way, and now mother's in a much better position and father's in a worse position, so the court can look at custody again and switch custody if needed, if it's in the best interest of the child. So here is just some information on different contact information, different self-help websites we have. We have all sorts of things online that you can look at, different videos, materials to read. If you are finding yourself in a custody situation, you can always apply for our services to see if we have an attorney that can either give you advice or maybe even represent you in court. But I believe, Susie, that's it on my presentation. And if there's any questions, I'll be happy to answer those.
Okay, thank you so much, Mindy. We do have some questions that have come in, and some of those were prior to today when people registered. So I'm going to go over those first, and then we can look at the questions in the question box, and hopefully you can provide some information on those. So first of all, if there is a, I guess, a DSS type of order where custody has been determined and it's approved a married girl, let's see, a girlfriend has moved in, and the 3 children or however many children are in the custody of this father, and an unmarried girlfriend is living there. So that might suggest an adultery situation. How is that viewed? Is that just a case-by-case situation? Is that a problem that would be, potentially a change of circumstances like you were just talking about?
I think it would probably be case to case. So adultery, I think when you're talking about adultery, if you're going through a divorce and one party is committing adultery, that's a factor that could affect alimony and could affect property division. It's usually not a factor that's going to affect custody unless the parent is exposing the child to their to the person that they're having the affair with. So usually the court would prefer that the person that they're having the affair with is not a part of the child's life at that, at least at that juncture while the divorce is still going on. I'm not sure if I understand the whole question, but maybe that answers it. I'm not sure though.
Yeah, I think that probably does. The next question we have is whether a court order can be thrown out when a number of years have passed by. Maybe there was a mistake in the order or something of that nature. Maybe, it just says a mistake here. I don't know if that means a mistake of law or fact or anything like that, but just asking what can you do after a period of years,
right,
as far as an order.
Okay, so I think that would a lot depend on what kind of mistake it is, and it would also depend on how much time has passed. But keep in mind, anything with custody, visitation, child support is modifiable with a substantial change in circumstances, meaning that court order could be changed. But if it doesn't have to do with those areas of law, a lawyer would certainly need to look at what the mistake is. If it was some type of fraud to the court, that might be a way to get around that. But for the most part, if the order has become final, like it's a final order and so many years has passed, it's probably going to stay final unless somebody files to modify it, just because you only have 30 days to file an appeal on a final order.
What happens?
Certainly, I was going to say, certainly talk to a lawyer about the specifics of that case. I think if somebody looked at it, they'd be able to give that person a better answer.
What if the order was temporary and there was never a final order? How does that work in child custody?
So in family court in South Carolina, usually when the case starts, you get a temporary order, and that order lays out what the parties are to do until there's a new order in place or until there's a final order. But if the parties don't go to mediation and don't finalize the case, that they don't take the steps they need to finalize the case, after 365 days of the filing of the case, the case could be dismissed administratively. The family court will dismiss the case. They could dismiss the case. And with that, the temporary order would be dismissed as well. So if it's only a temporary order, what you would want to do is look back into the case, go to the clerk of court, and find out if there's been an order of dismissal. And if there has, then that temporary order really is no good anymore.
Okay. And what about, how is custody affected by things like one parent being located in another state, the parent being unemployed, and those sorts of things?
So I guess it depends on the circumstances, but if the parent in the other state, let's just say like everybody lived in South Carolina and then one parent left South Carolina, and the child remained in South Carolina, then the fact that the parent left South Carolina and maybe is unemployed or not as stable as they should be, then certainly the court's going to be looking at which parent can offer more stability for the child and which parent, hasn't made this abrupt change. And we don't know why this parent left. I mean, it could have been a legitimate reason, but I think it just depends case by case, why they're unemployed, why they left the state. If maybe both parents were in a different state and one moved to South Carolina, well, that's a different scenario. So it just depends on the reasoning and, how often has the parent in the different state visited with the child. I mean, has it been years since he's seen the child or she's seen the child, or has it just been a few weeks? So I think certainly all those factors would weigh into what decisions would be made by the court.
Okay. So if the parent who has the child lets the child go and visit her in-laws or his in-laws, can the other parent, well, I guess what happens if the other parent gets them from his parents and tries to just keep custody of them? Is that just another factor in custody, or how does that work?
Well, I think it depends on whether they're married or not. That would be the start of the analysis is, are you married to this person or have you been to court? So if you haven't been to court and you've never been, let's say you've never been married to the father, and you haven't been to court over custody or visitation, then if you were to drop the child off at in-laws and then they gave the child to the other parent, the mother would still have legal custody. Okay, but if they're married, then they have joint legal custody. So either parent could, yes, take the child and refuse to give them back. So that's certainly, like, if there's been a recent split up or breakup, that's certainly something you need to contemplate on. That could happen if you have no court order and you have and you are married to that person.
Okay. And what about a custody case in another state by an aunt or uncle who I guess who lives in that other state is what the question is.
So I would probably need some more facts on that, but if the child's been living in that other state for more than 6 months prior to them filing for custody, then that state would likely have jurisdiction to decide that factor. And of course, I'm not licensed to practice law in any state other than South Carolina, so you would want to consult with an attorney in that state. If the child has not been in that state for more than 6 months prior to the filing of the case, you would want to consult with a South Carolina attorney, probably to draw them into South Carolina. That way you can litigate in your state would be
Okay.
the best. Okay.
Okay, now here's another question. And what happens, and I think you touched on this a little bit, but there may be other factors, but what happens in the death of a custodial parent? So one parent has legal custody and then they pass away. Does it automatically go to does custody automatically go to the other parent, even though they didn't have the custody order in their favor?
So I think it depends. If they had joint legal custody, then yes, I think it would revert to the, like if they had joint legal custody with mom as the primary and dad as the secondary custodian, and mom passes, then yes, dad's going to be the custodian. But if you have a situation where where paternity's never really been established, dad's not on the birth certificate, they've never been to court, mom passes away, and an aunt is now raising the child. Certainly, if the aunt establishes that she's going to raise, keep the child, if she keeps the child for a significant period of time, she could petition for custody. But if dad has established paternity, then it's probably going to be in dad's favor, because if he's a fit parent, he's going to get custody over a third party.
Okay. Now you talked about when the child gets to say what their preference is for custody at certain times. How does it factor in if the child is a special needs child in the court looking at what the child's preference is?
Right. So I think it would probably depend on what type of special needs child we're talking about. There's a lot of high functioning special needs children. So I think that's going to weigh heavily on the court. And I think that would be a case to case basis. So if it's a child that maybe is not as high functioning, then obviously there's going to be less weight given to their preference.
Okay. And here's a contempt of court question. And this is certainly relevant right now with COVID-19 virus and the restrictions that are in place in various states or various even areas within one state. And the question is, what if I did not allow my child to travel alone or even at all to an area where the other person lives, if they're, I guess if there's if it's a red zone or whatever, if it's a area where there are heavy numbers of cases, is that contempt of court? Is that a reason to not be in contempt of court?
So if there's an order requiring you to give up a certain amount of visitation, and you have decided not to do it because of the COVID restrictions, the other parent could file a petition for contempt of court, but what they're going to have to prove is that you willfully violated the court order. And what I do know is that judges are frowning on people that are denying visitation due to the COVID restrictions, because there's really not, your home could be just as dangerous as the father's home or the mother's home or whatever. It's best to try to work something out with that parent, maybe say, okay, he's not going to travel for Thanksgiving, but I'll give you extra time this summer or whatever. And if the other party agrees, then that's great. You could also try to agree on he's going to wear a mask, everybody's going to wear masks, or everybody's going to do this, this, and this to try to make sure he's safe. But I think that just denying the visitation just because you presume that your home is safer for the child than with the other parent, yes, you could be held in contempt of court for denying the visitation if there's a valid court order in place.
Okay, now here's one about the cost. You mentioned all the things that people have to pay for in a custody case, and there's a question about what you talked about the cost of depositions, and so what is that? Depositions.
So a deposition is when the opposing attorney will question you, or you can question the other side. So questioning a witness, and it's under oath with a court reporter, but it's not in court. So it's sworn testimony taken prior to court, and it can be used like if you change your story in court later on, it can be used to impeach the witness. But it can also be used to kind of help you know what the other party's going to say before you go to trial.
Okay. And are those used a lot in family court, or do you see those a lot?
Yeah. So if the parties have the money to pay for them, they're used a lot. But obviously, if a lawyer knows that their client can't afford to have a deposition, they're probably not going to schedule one. Now, they may have to defend on it, but yes, they are definitely used in family court.
Okay. And we're really out of time and have gone over a little bit, but there's a couple more questions I'll just let you give a quick answer to. And of course, there's really no quick answer to a lot of this, and most people should, obviously, as we said at the beginning, get the advice of an attorney about their particular situation. But there's a question about when someone has been ordered to pay child support, but they haven't done so, is that contempt of court? And I mean, I think the answer to that is certainly yes, that's contempt of court if an order is requiring that. But just because it's contempt of court, I guess, doesn't mean there's anything automatic happens until the person is held in contempt of court through another order. Is that fair to say?
Right, right. So either that person, the person who's getting paid the child support, would have to file what we call a rule to show cause or contempt, or if the child support orders through DSS may file it, or the clerk of court may file it if they're ordered to pay through the clerk of court. So that proceeding would have to be brought before the court before they're actually held in contempt of court. Yes.
Okay. Now, this is an interesting, I think, follow-up about COVID, talking about having to send a child to visit another parent in maybe a high COVID area. And if the child is going to have to go into quarantine for 14 days when they get there, but they have to be back before that time is even up, how does that affect things? And I guess it probably has to do with whether or not that means the visitation period that's been ordered will be up, or if they have to like be back for school or something of that nature.
Right.
That may or may not be something you can answer, but it's interesting.
Yeah, and it's hard to say. So I guess it depends on where they're going, and if we're talking about, into a city where the city's completely shut down and you have to quarantine for 2 weeks or whatever if you return. I know a lot of our restrictions in this state have been lifted, so it's probably not much of an issue now, but But the biggest thing is if you can't comply with the order, if you think you can't comply with the order, you probably need to hire an attorney and seek a modification of that order prior to just outright denying the visitation. Because what you're doing is you're putting yourself in a position to be held in contempt. There does have to be a willful violation of the order to be held in contempt. So I mean, if I was advising a client on that, I would advise to follow the order, absolutely, if you can. If you can't, then you really need to file a modification prior to violating the order.
Well, listen, Mindy, thank you so much. Those were great answers, and I want to thank you for a very informative presentation on child custody in South Carolina. There are so many different branches of that issue, and that was really a great and thorough overview. And I want to also thank all of you who joined us today. We really do appreciate your interest in this subject matter, as well as the other ones that we look at in Level Up Law every week. So I want to be sure everyone knows that Level Up Law is a series of free legal webcasts that we have every Tuesday at noon to educate the public on some of the legal challenges that are most commonly faced by our clients. And certainly today's subject, child custody, is one of those. You can join us every Tuesday. Also, you can find a recording of not only this webcast, but also all of the previous Level Up Law webcasts going back to June of this year on our YouTube channel. So just go to YouTube and search SC Legal Services, go to the Level Up Law playlist on our channel, and you can find all of those. And be sure to like and subscribe. We always want you to sign up for notifications of what's coming up next. Another way to do that is to just check out our Facebook page or follow us on Twitter and Instagram. So give us a day or two to get this one uploaded, and you can listen to this one again or any of the others. Now, you can see here on the screen all of our information. As Mindy said, if you have an issue and you need legal assistance on this or any other subject that we cover, and you can't afford a lawyer, you might be eligible for our free legal representation. So we do want you to apply for help, and here's how to do it with all the information right here on the screen. And I do want to point out, it's very important to know that we do have online application at our website, lawhelp.org, and that's also here on the screen. So if you can't apply during the hours of Monday through Thursday from 9 to 6 when our intake office is open and our intake specialists are standing by during that time, you can also apply online any time of day, and we will take that application and get back to you for any details that we need. So be sure and check that out. Again, I just want to thank you again for tuning in to Level Up Law, and we do hope that you will tune in again next Tuesday when we will be talking about mediation in South Carolina and how that works. So I want to thank you again, Mindy, for a great presentation, and that concludes today's webinar. We look forward to having everyone back with us next week for mediation in South Carolina. Thanks, everybody.